Let's find out more from Joseph Kotrie-Monson, who's Director of Monson Solicitors, the national law firm. Joseph, good evening to you.
Good evening, Clive.
Can you take us through in layman's terms what's been decided today then?
Yeah, absolutely, Clive. And I suppose the first thing to understand is that this was crucially not an assisted dying judgment in the way in which we might understand it, and similar to the cases where people have said, well, I would want to know whether I can go to Dignitas or or have the assistance of a partner or anything like that. As you've said, it was a judgment relating specifically to the withdrawal of food and water to a patient in a permanent vegetative state. And here's the big annex to that: it's in circumstances where the family and doctors already agree. So, if people are thinking, well, this is like the Charlie Gard case or whatever, this is actually in circumstances where family and doctors agree, and whether the court has a role in granting permission. And the very narrow question was not whether food or water should be withdrawn, but whether the doctors, as you said, need to apply to the cause of protection to do so, because that's been the practice, probably not the law, but that's been the guidance, certainly since the early 90s.
So has that been too much of a palaver and maybe an unnecessary procedure to go through, and cost as well, I presume?
Well, Clive, you're right. Certainly that's the official narrative. Although when people are talking about cost and life in the same sentence, I think any citizen should be very concerned, especially in these times of austerity. But you're right. One reason which the NHS Trust in question asked for this guidance initially was that as things stand, this can take years and cost a minimum of tens of thousands of pounds. And it's not just a financial burden but on the trust, but of course an emotional burden in terms of the time on the family, who of course are in agreement. And of course, Clive, as medicine advances, aren't we seeing that it's increasingly possible to prolong the appearance of life in a patient, even if for the purposes of that patient's family, or in their view and the view of his or her doctors, that life in any real sense may have departed. And you may have heard that the figure bandied around today is there may be as many as 3,000 patients and their families at this moment for whom such a tragic scenario applies. And already in, for example, the withdrawal of dialysis or the switching off of a ventilator, these are all things that where there is agreement, this is not a matter for the courts. I have to say, however, that the fact that more caution has been expressed by the courts in respect of artificial provision of food and water, I think intravenous drips when I say that, it is perhaps actually because simply giving this to the care of a doctor with no judicial oversight, that may be seen as a lurch in the other direction. On the one hand, the courts are now saying we are not going to be involved in this, but what does that leave? Well, that means that there is guidance in respect of doctors, and there must be, I suppose, arguments on the other side that suggest, well, is this a slippery slope to have no regulation, simply the doctor's duty on the one hand and agreement with the family? That could become nurse clinicians' duty. That could be something that's dealt with at a much lower level and susceptible, if it's not regulated, one might argue, and I don't have an opinion for the purposes of this call either way, or this interview either way, but might be regarded as perhaps too light touch of regulation.
All right, Joseph, thank you very much for joining us.